This Honorable Court of Appeals of Tennessee is in session.
Thank you, Ms. Dempsey, and on behalf of Judges Bennett and Easter, we welcome counsel to this oral argument, which we are live streaming in order to fulfill our obligation to maintain the open courts. We will conduct the hearing today in the same manner as if we were all together in the courtroom. Each of you has 15 minutes to argue, and the clerk will set the timer that you'll see on the screen. Unless there are any announcements, I will ask Ms. Dempsey to call the case.
New Dairy, Kentucky, LLC versus Mike Tamarit.
Mr. Hofstetter, you have the floor.
Good morning, Your Honor. Can everybody hear me? I always worry about this system.
I can hear you.
Thank you.
The system's working so far.
Thank you. To better understand the case, I think we need to have a little bit of the background of how the arrangement between Borden Southern Dairy and the appellee came into existence. About the end of 2013, the appellee had been in the business of directly selling and distributing its dairy products in Tennessee. In early January of 2015, they apparently made a decision that they would go to using distributors to handle the distribution process. So in early 2014, representatives of the appellee contacted Mr. Tamarit, who is the appellant, about possibly becoming a distributor. Why they contacted him apparently was because he had been a distributor for over 30 years of Boar's Head's products and understood product distribution. In connection with possibly doing a transaction, the appellant formed a limited liability company known Borden's Dairy and Distribution of Tennessee, a Tennessee LLC. In connection, the appellee and the appellant, a credit agreement was prepared. Credit agreement was prepared by the appellant. He filled in their blank form. He signed a blank guarantee. And the credit app does not specify credit terms. It's more in the concept of giving credit. But following that, the appellee and the appellant entered into a distribution agreement. The distribution agreement itself has the credit terms. It's net 30 invoice. That's in early 2014. We jump forward to 2015. Somewhere in early spring or something, the date is not certain, appellant transferred and sold his interest in the LLC to a fellow named Mr. Joe Beater. I have a hard time with his name for some reason. But he sold his interest to him, and the sale was what in my world is called a membership interest sale. It was not an asset sale. And the obvious reason for that was it maintained the entity status of Borden Southern BSD as a, may I refer to Borden Southern Distribution as BSD, it's just simpler to me. It maintained BSD's legal status without requiring any change to it. It also allowed the distribution agreement to stay in place because no parties were changing. However, after the ownership changed, so I call it the post-ownership period, some 8 months, the appellee says it did not learn of the ownership change until about mid-June. But about 8 months later, the lawsuit was filed. The lawsuit was for an alleged $60,484.95 alleged debt, saying that BSD had not paid invoices for the period between 4/26/15 and 5/29/15. If we look at the public records of the Secretary of State, we realize that Mr. Beater had amended the Secretary of State's records by an amendment dated 5/15 of 2015 to appoint himself as the registered agent and change the registered address for the company to his house. The summons for the lawsuit was issued. Shortly after being served on Mr. Beater, the appellee non-suited the case. That question was of interest, is the question there to me is an interest. Why did the appellee non-suit the case at that point for the debtor who created the debt when the appellant had not even been served? Fast forward another 18 months later, and the issue of the appellant being served starts to surface. The service was attempted by certified mail through the Secretary of State certified mail, and it was not delivered in January of 2018. My client spends a majority of the time living in Brazil, not in the United States. So that complicated things a fair amount. But in late February of 2018, my client actually finds out that this notice for default has been filed by the appellee. He contacts me, we contact counsel, and we file an answer in the case. So we're now up to into March of 2018. The next thing of significance that happens is the summary judgment hearing. The court found that the appellant was liable on the personal guarantee because he signed the personal guarantee. The damage issue was deferred as considered a material fact and to a later hearing. However, the facts represent that both before, during, and after the lawsuit, BSD and the appellee have continued to do business. On 11/10/2020, the identity of the plaintiff changed. And I say the plaintiff because the original plaintiff went into bankruptcy, and all of the original plaintiff's assets were sold to a company called New Dairy LLC. And New Dairy LLC was simply a substituted plaintiff. We get to now what happens on the 11/17/2020. We have the damage trial. Appellee's expert, our custodian of records, Ron Knox, he testified changing of the BSD account number when Beater became the owner. Appellee testified that its liabilities are determined on who owns the company. When appellee changed the account number, it did not include this alleged debt. We get to where we are. There was no transcript, but counsel and I agreed upon what was in the statement of evidence. The appellee's records were produced through this Ron Knox, who testified. 5 exhibits went with that. The judge, in his opinion, said he found the argument that BSD, as a continuing going concern and continuing to get credit, was without merit, and that because the account number had been changed. However, if you look at Exhibit 5 to that testimony dated November 5th, 2020, the appellee's coordinator for their account receivable coordinator refers to BSD as an awesome count customer and shows that BSD is complying with all the credit terms. And you'll see that this alleged debt is not shown as a outstanding invoice on BSD. Now we get to the guarantee agreement. In my world, the guarantee agreement's purpose is to assure the debtor that if the creditor can't pay, then there's a source for repayment. The guarantee agreement is a contract. Tennessee recognizes that contracts are subject to the doctrine of good faith and fair dealing. In general, every contract in Tennessee contains an implied duty of good faith and fair dealing. It requires that neither party will destroy or injure the right of the other party to receive the benefits of the contract. Though there's no specific definition for good faith, it's generally defined as honesty of the person during the agreement and fair dealings that is in keeping with the spirit of the contract. The courts have the discretion to determine the duty, and deciding if good faith and fair dealing are particular in this situation. In this particular situation, the guarantee agreement had the language that provided that the appellate would pay when payment was not made by Borden Southern BSD. He had a right to expect that BSD would make its payments. The credit agreement didn't specify anything about account number changing, but what we've seen through the actions of the appellee in this case, they suggest something of an underhanded activity. Appellate changed the account number. There was no logical reason to change the account number. The court relied upon the change the account number. The appellee relied upon the change of the account number, justified its pursuing the appellate, and justified it not seeking payment from BSD.
Mr. Hofstadter, doesn't the agreement, personal guarantee agreement, state that your client was waiving any right to require the seller to proceed against or make any effort at collection of the guaranteed indebtedness from the company liable for such debt?
It does. But if you look back at the specific language, I agree to bind myself to pay on demand any sum which is due by the company, the seller, whenever the company fails to pay the same. That was a condition. I viewed that as a condition of payment. I owe it if they don't pay. And the concept here is they chose, not for reasons I don't know, not to go after the debtor. They chose to ignore the debtor, pursue my client, continue to do business with the debtor, and it suggests that there's something that happened that we don't see. I mean, the alleged debt had to be obvious of a breach of contract in the credit agreement because the terms of the credit requirement required it to be paid net 30. It continued to extend credit. It failed to seek payment from the debtor and continued to pursue the guarantor.
Was there anything in the sale agreement of the company that said that the debts would incurred prior to the sale would continue to be debts of the company or anything like that?
No, Your
Didn't
Honor.
address debts of the company, just sold the company.
It sold the membership interest. It did not sell the assets.
Okay.
And in my world, that gets to be a pretty important thing in a transaction. When you're selling the interest, you want to know what the debts are, what their status is, et cetera, because I would say more than half the time sales are asset sales if they're small instead of stock sales because of just what Your Honor said, the sort of lingering liability that could be in the weeds. But in this case, it was a membership interest sale, and the entity has remained an active, valid Tennessee LLC all the way through. And so I find it to ignore that it is a legal entity sort of says, wait a minute, this makes no sense. And what has bothered me about this, I called it red flags. One, the failure to respect and appreciate the legal entity status. And second of all, the efforts expended by the appellee for the protection of Borden Southern BSD from paying the dairy products BSD purchased and focuses interest on collecting from the appellate a debt that was the rightful debt of Borden Southern BSD doesn't seem to make much sense to me. And that's when I use the word underhanded. How did all this happen? How did it that the debt of BSD gets ignored? How do you look as a creditor? How do you look away from the debtor, deciding to focus on the guarantor, where the guarantee agreement terms says that the guarantor only pays if the debtor fails to pay? And
not Mr. Hofstadter, should not your client have filed an answer and a third-party complaint against the business, the membership, your client's former business?
Our client, for reasons because they are friends, well, if turns out has to pay this, will actually go after the company under the contribution it would owe by being the obligor of the debt.
Okay.
And I've got a case right now where they wouldn't sue his mother, and his mother caused the problem. Those things just come up. You make a decision in life that maybe lawyers don't quite agree with.
All right. Thank you.
Any other questions?
Hearing none. All right. Thank you, Mr. Hofstadter.
Thank you.
Mr. Brown.
Good afternoon, Your Honors. May it please the court, my name is Tyler Brown. I'm part of the Blount County Bar and represent the Applee New Dairy, Kentucky LLC in this matter. Please note that for the purposes of this oral argument, I will refer to the Applee by its former name, Borden Dairy, as the facts of this matter all occurred while the Applee was doing business under that name. Mr. Hofstadter has already gone through the facts of this case, so I will not linger on them unless the court would like me to hit on any particular issue at this moment. Otherwise, Your Honors, this case and the only issue presented for review should be fairly straightforward. The sole issue is whether the trial court erred by holding that the appellant is personally liable for the subject indebtedness. As I will discuss, the applicable facts and law lead to the simple conclusion that the trial court did not err in holding appellant personally liable for the debt. First and foremost, as noted in both briefs, a trial court's decision whether to grant or deny a motion for summary judgment is a question of law to be reviewed de novo with no presumption of correctness. Summary judgment is proper where the pleadings, depositions, answers to interrogatories, and admissions on file, together with any affidavits, if any, show that there's no genuine issue as to any material fact and that the moving party is entitled to judgment as a matter of law. The non-moving party must demonstrate the existence of...
Mr. Brown, I don't want to interrupt your argument, but we can read the standard of review. I want to know what undisputed facts the trial court relied upon and you rely upon in this matter.
Understood, Your Honor. In this case, the evidence in the record unambiguously shows that the appellant executed a credit application and agreement on behalf of Borden Southern and in favor of Borden Dairy. The parties are clearly identified both at the top of the credit application and in the body of the first page. The appellant admits that he signed the document on January 26th of 2014. He argues that the identity of Borden Dairy could not be determined from the credit application and agreement, but then admits that Borden Dairy of Kentucky LLC is identified at the top of the application. And additionally, the credit application clearly shows Borden Dairy's logo, its legal name, and its address as well. And both the terms agreement and the individual personal guarantee identify the seller as Borden Dairy. In light of those facts, the defendant can't argue that the credit application and agreement are ambiguous as to who Borden Dairy is, which is one of the arguments raised in the appellant's brief. But it would require a strained construction of the language in the application and agreement to find an ambiguity where one does not exist.
Well, if it isn't ambiguous, why, as to who the obligor here is, why would you not go after Borden? I forget what they're called. Whoever the distributor.
Southern.
Yes, the distributor instead of the guarantor.
As Mr. Hofstadter mentioned, Your Honor, when the sale of the business took place, our client, which didn't learn of the sale until sometime after it happened, it assigned the new customer number to Borden Southern after that sale. Payments on that new account came from a different source.
But it's still the same company.
Yeah, you're not answering the question.
It's not. It is the same company, Your Honor, but the ownership is different. Mr. Beater,
What
the current
difference
owner.
does
Why didn't you sue him? The question is, why didn't you sue him?
We did originally sue them, Your Honor. We
but you
dismissed
threw in the towel on that one. Why'd you do it?
because our client instructed us to. They contacted us and said that this debt was accrued while Mr. Tamarit was the owner of the business and that he should be the party responsible for it. As Trial Exhibit 5 does show, the current entity of Borden Southern is current on its accounts, which those.
So your client said Well, the company was owned by somebody different then, so you should sue that person. You did what your client said, even though it might not have been a very good idea.
Well, Your Honor, the guarantee was signed by Mr. Tamarit, and the debts subject in this case were incurred while he was the owner of the business. And Your Honor, the terms of the guarantee are very clear that he's binding himself to pay for those debts.
If the company doesn't pay, right?
Correct. And the company did not pay, which is why the suit was filed.
You didn't do much to try and get the company to pay. Did you send a demand letter to them?
Yes, Your Honor. There was a demand letter that was sent to the company that was in Trial Exhibit 2 that was sent both to the company and to Mr. Tamarit himself.
Is a response from them from the company in the record?
I don't see that, Your Honor, no.
So we don't know what the company said. Okay.
But what silver bullet are you relying upon to say that this individual defendant is liable, even though you haven't gone after the business entity?
Your Honor, the terms of the guarantee clearly state that the defendant, or excuse me, that Borden Dairy does not have to pursue anyone else for this debt. It can pursue the guarantor himself, and the guarantor waived any right to require Borden Dairy to pursue anyone else.
All right.
So that's what our client chose to do. Mr. Tamarit, again, was the owner of the business at the time that the debt was incurred. And again, payments were not made. And as a result, our client has chosen to pursue Mr. Tamarit for payment of those debts. And I'll note, Your Honors, that in Tennessee, guarantors in commercial transactions are held to the full extent of their engagement, and the words of the guarantee are to be taken against the guarantor as strongly as the sense will admit. In cases like this, a continuing guarantee is one in which is not limited to a particular transaction or specific transactions, but which is intended to cover future transactions until revoked. And I think it's notable, Your Honors, there's no indication here that Mr. Tamarit did attempt to revoke his personal guarantee. There's nothing in the record, and I certainly don't recall seeing anything where he notified our client that he had sold the business. He didn't send a notification via certified mail, which is what the guarantee requires he do if there's a change of ownership. And because
he should have done that, it's my understanding that your client has not sued him for any money or debt that it incurred after he sold his membership. Is that correct?
That's correct, Your Honor. The debt here was only for products that were purchased in April and May of 2015. And once
while he was the sole member of the entity that the product was sold to.
Correct, Your Honor. And again, our client wasn't made aware that that Borden Southern had been sold until mid-June of 2015. But looking back to the guarantee and applying the standards for summary judgment in this case, the trial court found that the defendant signed the personal guarantee and was bound by that guarantee. And in his brief, at least, the appellant appears to argue that the trial court was mistaken in doing so because the guarantee was ambiguous thanks to its blank lines. The defendant admits, however, to signing the guarantee on the line above the word guarantor. You can see that in his response to request for admission number 4 in the transcript of evidence, volume 1, page 20. Clear, unambiguous, and objective conclusion from his signature above the word guarantor is that the defendant was agreeing to bind himself as the guarantor. There's simply no other reason for him to have signed it on that line. He also argues that the guarantee is ambiguous because it doesn't identify who the guarantor or the company are within the actual terms of the guarantee. However, as I just mentioned, the defendant's signature is above the word guarantor, and equally obvious is the fact that Borden Southern is the company to whom Borden Dairy is extending credit. That's so because the guarantee is on page 2 of a 2-page credit application and agreement. The credit application, the first page, which was filled out by the appellant himself, states on its face that it's for Borden Southern. So the clear and unambiguous intention of the parties is that the party applying to receive credit is Borden Southern.
Mr. Huffstutter made comments about the fact that the Borden Dairy sold its assets. Would you, and he seemed to say that that should be a deficiency in your claim. Would you address that?
Yes, Your Honor. And we addressed that when we filed our response to his motion to dismiss in the original suit. Our client purchased all of the assets of Borden Dairy, and that included its right to pursue this lawsuit, as unpaid accounts receivable are, at least in my opinion, considered assets of a business. And so our client properly went through those procedures and properly asked the court to be substituted into this case as the proper plaintiff, and was granted the right to do so. Did that answer the question?
So the action was commenced by Borden Dairy, then Borden Dairy sold the assets to New Dairy Kentucky, and New Dairy Kentucky substituted as the plaintiff.
Correct, Your Honor.
Okay. All right. Anything further?
Sorry, I was trying to find where I was.
Sure.
Quickly, the appellant doesn't argue that he did not sign the credit application agreement, or that he did not understand what he was doing when he signed it. Instead, once suit was filed against him, he simply decided to assert that the document was ambiguous, and apparently that he did not know what it meant. Viewing that assertion in light most favorable to him, the court should still find that the credit application and agreement are unambiguous. The appellant guaranteed the payment of any amounts owed to Borden Dairy by Borden Southern. Borden Dairy provided goods to Borden Southern while appellant was president, but payment was not made. And as a result, appellant was and still should be liable for the subject debt. Because there was a valid contract between the parties in the form of the credit application and agreement, which includes the guarantee, and because Borden Dairy proved the amount of its damages at the evidentiary hearing in November of 2020, there are no genuine issues as to any material fact. The appellant has failed then and has failed now to demonstrate the existence of specific facts in the record, which could lead a rational trier of fact to find in favor of him. And as a result, Borden Dairy was and is entitled to judgment as a matter of law. And that's all I have, unless your honors have any other questions for me.
All right. Hearing no questions from the other members of the panel, thank you, Mr. Brown. And I understand Mr. Huffstutter did not reserve time for rebuttal. So thank you, Mr. Huffstutter and Mr. Brown both. We will take the matter under advisement. Ms. Dempsey.
This honorable court, it stands adjourned.
Counsel, you are free to exit the meeting. Thank you.
Thank you, your honors.